that it can't be changed till Parliament changes it. They give the power to Parliament, but this is an evolving situation. They give inequality issues relating to how we ameliorate the conditions of those who have been sidelined for centuries, who have been humiliated for centuries, who have been ostracized for centuries. I don't think we can ever imagine how they were dealt with in the context of the caste structure that prevailed. I think that the constitution makers in 1950 realized this. That is why the notification was issued in 1950. And they also realized that this is not going to stop, because they gave the power to Parliament, but this is an evolving situation. They gave power to Parliament to deal with the matter, and it's unlikely that this is going to end very soon. It is in that context, Malad, that we must look at this matter. And what we can do, quite apart from reservation. For Malad, the two basic assumptions that Chanaya made, which were wrong, is number one, they considered the scheduled castes in the order as a homogeneous group. They assumed that this represents a homogeneous group. And I will demonstrate to your lordships that that assumption is based on no factual data. That assumption is based on no analysis of that data.
What they hold is that once they find the place in that particular group, then they are all part.
Homogeneous. What's the basis of that? In fact, heterogeneity is inherent in that.
Actually, the homogeneous nature of all the entries is for the purpose of designation.
Yes, absolutely.
They are homogeneous in the sense that each one of them is a scheduled caste. But your argument is that there is no homogeneity either in terms of the sociological profile, economic development, correct, social advancement, absolutely, educational advancement.
Absolutely. So that assumption in Chanaya was wrong.
Common factor is social and social backwardness, social and economic backwardness. But the degree may vary from one
entity
to another entity.
Absolutely. So the assumption of homogeneity in Chanaya itself is constitutionally flawed. That's the first mistake Chanaya made. The second mistake Chanaya made was that it correlated the presidential order with reservation. These are the two assumptions on the basis of which Chanaya was rendered. Neither of these assumptions is valid.
Because the designation is for the purposes of the Constitution.
That's correct.
It's not only for reservation, nor is it coterminous with reservation.
I'll go a step further. It has nothing to do with reservation. Well, that's the designation of this class has nothing to do with reservation. Reservation emanates from the plenary power of Parliament, which is in 16(4) for the purposes of employment.
Because Indra Swani says that it can be done even by executive instructions.
But now not anymore, Malaj. Because now it's Parliament has to make a law, Malaj.
What?
Now Parliament has to make a law to change the schedule,
Reservation, Indra Swani goes on to say that it is not necessary that there has to be legislation. It can be done even by executive.
Maybe so, Malaj, but that is not part of the notification. But that's nothing to do with reservation. My point is, Malaj, you are assuming
that may not be correct, because if there is a reservation for scheduled caste, so unless that particular entry finds in the place in the presidential order, that person from that is not entitled.
I just demonstrate that your lordships, wherever they wanted to give reservation, they have given it. Then reservation is part of 16(4) itself, as far as employment is concerned.
It's a necessary but not a sufficient condition.
Correct.
Designation under Article 341 is a necessary condition for reservation, but it is not sufficient in itself. Correct. Because having been designated, there is still an enabling power which is conferred upon the parliament, or for that matter, as brother says, on the executive.
Yes, but it's the union or the parliament, Manoj, but the order itself has no reference to resignation, reservation. What you have an agglomeration of various castes which are put together who have been humiliated for centuries. The heterogeneity is clear from the table itself.
Occupation.
That's right.
In terms of the resources or lack of resources.
Exactly.
In terms, therefore, of all the indicators of backwardness or development.
Exactly. So therefore, they are put in one class.
Social status. Yeah. The status of every caste may not be the same in the social hierarchy as well.
Exactly. So that
between them, some may be a little more advanced, some may be a little less advanced, people may be particularly underprivileged.
Correct. Absolutely.
In terms of other indicators like infant mortality, maternal mortality, fertility rates, which sort of define, broadly speaking, whether there has been progress in the social indicators.
Absolutely. Now that assumption was made by a observation of Justice Krishna Iyer in Thomas. And that's no, he said, he doesn't use the word homogeneity at all. We may clear the clog of Article 16.2 as it stems from a confusion about caste in the terminology of scheduled castes and scheduled tribes. This latter expression has been defined in 341 and 342. A bare reading brings out the quintessential concept that they, brackets, there, are no castes in the Hindu fold, but an amalgamation of castes, races, groups, tribes, communities, or parts thereof found on investigation to be the lowliest and in the need of massive state aid and notified as such by the president. To confuse this backwardmost social composition with caste is to commit a constitutional error, misled by a compendious appellation. So that to protect Harijans is not to produce prejudice any caste, but to promote citizen solidarity.
In fact, by using the expression, this mixed bag,
yes,
the learned judge is really underscoring the heterogeneity of the
Exactly.
Then in the latter part, he says, but as a large backward group,
that's correct,
deserving of societal compassion.
Correct. Now, this is quoted by Justice Hegde.
The way of doing it is that not to deny that they form a class, but they form a class for the purpose of Article 341.
That's right. Absolutely.
So they may be a class for certain purposes, they may not be a class for all purposes.
That's correct.
Basically what you said in your submission.
There is a level of, what should I say, discrimination, which runs through this entire list. But their vocations may be different, their historical, the way they were treated may be different, there may be so many differences. The numbers may be different. The extent of discrimination also may be different. Level of discrimination may be different. B6 and Dalit 6. Now, do you know what the origin of this is? The origin of this, what is the origin of Majbi 6? Guru Tegh Bahadur Mulaz, his body was mutilated. And he brought that body to Guru Gobind Singh. And he was a chamar. The person who brought that body was a chamar. So Guru Gobind Singh took him in his fold. And therefore the chamars became part of the Sikh community. Now what has that got to do with this list? That's the historical context. Yes, Mazhabi means faithful.
There is also an entry with regard to chamars.
Yes.
In Punjab.
That's right. And that's why, your lordships find that the 32% of the population of Punjab,
It's very group, completely.
32% of the population is Dalits. More than any other state in this country. Now with me, your lordships will realize, that in fact what Justice Krishna is saying is consistent with 341 itself.
Prima facie, that observation that it amounts to tinkering with the present list in the presidential order, that doesn't appear to be, because
Absolutely.
they don't say that if you remove comma or...
Absolutely.
Nor are they saying that this particular caste is a synonym of whatever is a designated caste, that include therefore this caste Not the state of Punjab arguing it, that though
No,
these
no.
castes have been not designated, these particular castes are also are synonyms or belong to the same. That you can't do. That even we can't do as
Exactly,
it's
exactly.
beyond.
Well, just one point. Your Lordship asked the question, why the word deemed is there?
Right.
Because I just wanted to answer that because
That
it is there because
That the learned AG wanted to know.
because Malaj, it can't be changed till Parliament changes it. It's deemed to be. Nobody can tinker with it. That's the reason why deemed is there.
I have given a history, which I am again not going to place before your lordships,
Yes.
as to how this developed. But the most relevant part is, slowly and gradually, your lordships on the judicial side has started taking note of the fact that there needs to be some rationing.
Right.
At the outset, I say, my lord, on behalf of the central government, Lord, it is not my submission about the reservation. Reservation as a policy, the central government is committed to. My written submissions, my lord, are only confined to the question referred whether there can be a sub-classification or not.
Right.
And sub-classification as a concept was bothering your lordships, my lord, and there are some judgments which reflect that.